Just so you have a roadmap of where we're going with the rest of our day, we're about to start the panel on state and local leaders on the future of alternatives to incarceration. After that, a little after 5 o'clock, we're going to have a reception in the Continental Ballroom on the 3rd floor. And in addition to refreshments and mingling, we're going to have a special tribute at that time with 3 guest speakers for the Honorable Jack Weinstein, who served for 54 years as a legendary member of the U.S. District Court for the Eastern District of New York. He was a pioneer in federal sentencing, and actually, you'll hear, encouraged the formation of the Olive Institute 42 years ago. And I'll say a little bit more about that when we get upstairs. For now, so let me introduce our moderator of the next panel, who will introduce our panel. Jenna Bottler is the president and executive director of the Justice Action Network, an organization that brings policymakers, stakeholders, and advocates from across the political spectrum together to advance strong, bipartisan criminal justice reform efforts at both the state and federal levels. For those of you who might be younger in the crowd, bipartisan is this phenomenon where people on both sides of the political aisle actually work together on something to accomplish it. A lawyer, yes, let's hear it for bipartisanship.
One person.
A lawyer, Jenna previously served at the Pew Charitable Trusts and the Center for Effective Justice at the Texas Public Policy Foundation. Jenna.
Thank you so much. It is such a pleasure and an honor to be here with you all today, and I very much appreciate being the thing that stands between you and the refreshments at the reception, so that's always fun. But I'm so excited to be joining y'all. This is truly a distinguished group of individuals who have joined to talk about these really important topics. Let me just express my thanks to the Center for Justice and Human Dignity and the Olive Institute for bringing together today's event. I was paging through the program and just blown away by the speakers that are here with us. So thank you all for what you've done on that. So for those of you who don't know Justice Action Network, as you mentioned, we work across the country on bipartisan criminal justice policies, all of which are data-driven, all of which are evidence-based, all of which have bipartisan support. And there's a lot more than than you would think. As you're going to hear a little bit from some of our speakers today, it is certainly a robust area of policy work across the country. But I know that many in this crowd are primarily federal practitioners. And so I wanted to just talk for a second about why it's so important that we have this view from the states. Why do we, as an organization and many other organizations out there, spend most of our time and resources in state legislatures? There's 2 pretty big reasons. One is, as you well know, the vast majority of criminal cases and people are flowing through the state systems. The vast majority of cases are in state courts. The vast majority of people are in state prisons. So state policy matters. But second of all, state trends and policy choices drive a national discourse on these issues. We saw this firsthand a few years ago when the First Step Act was signed into law in 2018 by then President Donald Trump. It was landmark legislation that sought to overturn many of the practices of the Bureau of Prisons. That legislation was made possible because of what's happening in the states, because of what's happening in Texas, in Georgia, in North Carolina. People saw those programs working, brought them to Congress, and it became law. And actually, many of the congressmen and women who voted for that were state lawmakers at one time and actually advocated for those programs as state lawmakers. So these issues truly matter. We're going to start by hearing from each of our distinguished panelists. Really excited to hear what they're going to share, and then we're going to dive into some questions, and then hopefully we'll have some time for questions from y'all as well. But we're going to start down at the far end of the table with Commissioner Rodney Ellis from Harris County. I knew him as Senator Ellis back in the day, back at the Texas Public Policy Foundation, where he served 26 years in the state Senate, which is no easy feat for anyone that's ever worked for the Texas State Senate. And there he passed hundreds and hundreds of bills relating to criminal justice and other very important issues. And I know he's taken a lot of those issues back home with him to Harris County, so really excited to hear from you. Commissioner Ellis.
Thank you so much. I have been waiting for a repeat of this conference since I went to the one at Columbia's Law School. I think that was about 2019, right? Or 2017. 2019. I do want to give a shout out to Hannah Dershowitz. She's around here working. So where are you, Hannah? Hannah was my policy director. There you are. She was my policy director in Texas in 2001. And if you think it's difficult to pass something in your state, move to Texas. And in that session in 2001, we passed a series of things. We do this deal where we rotate the person who's president pro tem of the Senate. It doesn't mean anything. It means that when the lieutenant governor who presides over the Senate is out, they put your name on a program. And usually you want to have it when the legislature's in session. So when the lieutenant governor goes to the restroom, you can stand up there like you're really directing something. As fate would have it, when would Rodney get it? When the legislature is out of session. In Texas, they have biannual sessions. You meet 140 days every other year. So when would I get it? The end of a regular session in 1999. So for a year and a half, yours truly was president pro tem of the Texas Senate. But a strange thing happened. Governor Bush was running for president, so he was always gone. And Lieutenant Governor Rick Perry and I had something in common. The running joke was for Governor Perry, Lieutenant Governor Perry, and Senator Ellis have ticket will travel. If there's somewhere interesting to go on the globe to give a speech and you pay for it, we go. So whenever Governor Bush was out of the state running, campaigning somewhere, and then Lieutenant Governor Rick Perry had something to do, guess who was acting governor of Texas? Me. So, I'd always been a bit of a criminal justice reformer, and I'd passed a few bills. Big fight every session for maybe 20 years was the hate crimes bill, where I was going to include, of all things, sexual orientation. It was really a law and order bill because I was trying to enhance the penalty if you committed a crime based on race, religion, and I could have gotten it passed. But I also included sexual orientation. It was a hot button. So from the moment I got to the Senate in 1990, every session, every 2 years, that was a big battle. And in 2001, it did pass. But so they assume because I was carrying this really law and order bill to enhance a penalty. In most states, we enhance all kinds of things. It's a higher penalty if you slap me while I'm a public official. If you slap me when I'm out, it's not. But there are numerous enhancements. Most state criminal statute codes are replete with enhancements. But so there was a little concern about what I'd do if an execution was scheduled. And I assured my colleagues that I held my hand up and I took an oath that I'd obey the laws in the Constitution of the state of Texas, including those laws that I didn't agree with. So there were a couple of executions, record number going on then, and I did follow through with the law in Texas. Then all of my left-wing friends would send in these briefs, knowing it was a day that I'd be acting governor. Never saying the person was innocent or making a case, but just basically saying, in much more fancy legal jargon, Rodney, you African-American. And the death penalty in Texas has a disproportionate impact on people who happen to be black. Then this one case came along, Hannah, Ricky McGinn, and that was a conservative trial court judge in West Texas, elected justice, elect judges, and he said you should get a DNA test. Well, we had no DNA testing statute in Texas. So I get this call from Barry Scheck out of New York, of course. I could tell from the accent he didn't have a southern drawl. And he said, Senator Ellis, I'm Barry Scheck. You may have heard of me. Yes, I have. How did you get my number? I'm just curious. And make a long story short, I granted a reprieve. You can only do it as governor or acting governor of Texas for 30 days. Governor Bush did agree. Lieutenant governor was, I think, in Normandy. Couldn't get back, so I had to do it. But I used that opportunity to put a spotlight on the need for a DNA testing statute in Texas. I think when we passed it in 2001, we may have been about the 13th state in the country to pass that statute. Now all 50 states have a statute. But I got to know Barry Scheck and the folks at the Innocence Project pretty well from that process. And I told Barry when I had him down for a press conference, with some of my more conservative colleagues, both D's and R's. When the legislature goes back in session, we're going to pass a compensation statute for people who are wrongfully convicted. We're going to pass my hate crimes bill. We're going to get this DNA testing statute passed. We're going to pass a discovery statute. We're going to get a bill passed to ban executing people who have MR. Term is not politically correct, but in the statute, you have to say MR. And Barry looked at me like I was on something. But lo and behold, we did get about 3 of those passed. But along the way, I learned a valuable lesson, how you could take someone's story from a wrongful conviction and use that as a clear bully pulpit to make a case to my colleagues on the left or the right. They did make me chair of their board, so I served as chair of the Board of Innocence Project out of New York for about 14 years. I stepped down my second year as a county commissioner. Best practices on not-for-profit boards should rotate it. But one bill we passed that was particularly enlightening, perfect example of how legislating is really storytelling. I saw an article in the local paper where a guy had been wrongfully convicted. He got his pardon for innocence from Governor Bush because when that DNA testing statute did pass, he saw about it. He saw it in the paper and went in to get tested. And he came into I called his lawyer and I said, who's your guy? I'd like to meet him. And, you know, the lawyer's job is to make the case. So he said, well, when would you like to meet him? I said, in an hour. I didn't want him to prep the guy. I wanted to see if he could be a good storyteller and get his bill passed. So he came in and he met me, had his jeans on. You know, I don't think he had socks on with his shoes. And, you know, you're talking to a Texas state senator. We wore socks around the Texas Capitol. But he met with me and Hannah. Hannah left a big law firm because she wanted to do criminal justice reform work. Probably cut her pay, you know, to maybe 20% of what she was making to come in and work for me. And we used him as our poster child to pass the Fair Defense Act in Texas, nowhere comparable to what you do in terms of indigent defense in many of your states. But for Texas, you know, the Supreme Court in Gideon said that states have the responsibility to provide a lawyer if you cannot afford one. But in Texas, they left that responsibility to finance it to the counties, 254 counties, with no money. So with Hannah's help, we passed the Fair Defense Act. We set standards, you know, for how many cases someone could have. We set standards on how long you could take to appoint a lawyer. Pretty good. I mean, particularly for 2001. But in my case, in terms of legislating, I think I was able to get some bipartisan support because I would use people who were wrongfully convicted and look for issues that had nothing to do with a wrongful conviction, but I would have them as my byline to tell a story. And I'll close on this. One thing that helped a lot on the Fair Defense Act in Texas, which was a model for the country. Many states did things that were much more progressive, but to have gotten that passed in Texas, I know the policy team at the Innocence Project would put me on the road and say, if this passed in Texas, you ought to be able to pass it somewhere else. Eventually, we did pass what was considered the strongest state discovery statute in the nation. We did not do reciprocal discovery. Both the plaintiff's bar and the defense bar gave me hell on that one. They even questioned whether or not I deserved my law degree. But we did pass what was the strongest discovery statute until New York passed one that was stronger. And Justice, they passed it because when I went up to testify, some of the members, back then it was 3 men in a room, would make all the decisions. Now it's 2 women and a man in the room. Speaker, the governor, and the president of the Senate. But so it helped to pass your statute in New York because they could say that discovery statute passed in Texas, and so far we've not gutted it. We also were the place. I'm in county government now. Young guy out of D.C. with the Civil Rights Corps who was at this conference back in 2019. came, and he had this bright idea of suing Travis County, Austin, because he thought they were liberal. And I said, you think that until you start messing with the bail bondsman. So I said, if you want to bring light to a dark place, sue Harris County. And as much as I can legally give you in terms of discovery without violating any open records laws, I'll do it. So he did sue for misdemeanor and felony bail, misdemeanor bail in Harris County. So deep in the heart of Dixie, of all places, I'll close on this point. The same theory was used to challenge our misdemeanor bail system. We ended up with a very well-respected Republican federal judge, Lee Rosenthal, appointed by Bush 1. And it was the same argument to strike down our bail practices in Harris County, wealth-based detention. Same theory Thurgood Marshall used to integrate this country to a great extent. Same theory that was used for Hispanics to get many of their rights, and the same theory that was used to give women many of their rights. In theory being, if the 5 of us on trial and we come up for bail, we're accused of a crime, 3 of us have money, justice, the 2 of us don't, and we stay in, they get out. That violates the Equal Protection Clause. And that was persuasive to Judge Lee Rosenthal. And that is what prompted Cook County, and it was a shout across the country. And then on the felony side, Dallas County went to the Fifth Circuit and pretty much knocked the wind out of that argument. But at least we settled the case in Harris County. And at least until that settlement expires, we no longer hold people on misdemeanor bail simply because they don't have money. It's an honor to be here with Representative Simmons and Justice Swern and also Chief Assistant Talpins. And Hannah, thank you for inviting me again.
Good
Thank you
afternoon,
so much.
everyone.
Oh, so sorry, real quickly. Just going to introduce you real quick, if that's okay. But thank you so much, Commissioner. Really appreciate your time and your expertise. You certainly do know how to gain bipartisan support, even in a state like Texas. I can only imagine how many calls you got from Shannon, from the district attorneys after that discovery bill. So next, I'm very pleased to introduce Justice Ann Swern from the Supreme Court of New York. But she's also served in virtually every other role possible in the criminal justice system, both as a prosecutor and as a public defender. And just reading through your biography last week, I was amazed at how many programs you've initiated that we're now replicating across the country. So we'd love to hear a little bit about your story.
Well, if you couldn't tell from Commissioner Ellis, I'm from New York. And every time he mentioned New York, he looked at me and my accent and everything else. But I'm very proud to actually be here talking about what New York has done and what New York is doing. First of all, I'm so delighted to get invited because Judge Donald and I were probably at the first, if the Aleph, right? I mean, would you say the first or second time Aleph ever did this? And we were at Georgetown together because we were on the Criminal Justice Council of the American Bar Association together. So when they invited me, I said, oh, I get to see Judge Donald. I'm so excited. And then I'm seeing all of my other friends that I've done all this work with for so many years. Raul Ayala and I sat on a commission together. Judge Gleason and I have actually done state and federal work together. He was a professor teaching a federal course. I was a professor teaching a state course and doing state work, and I actually taught his class. So a lot of the themes of today I've had experience with, and also bipartisanship in the criminal justice system, because as Jenna said, I was a prosecutor for 33 years. I was the first assistant DA in the Brooklyn DA's office. And then I got a job as managing counsel at the public defender's office. And I dare say nobody's gone from being the chief assistant in a DA's office to being managing counsel in a public defender's office without actually doing the equivalent of what bipartisan work looks like in a legislature. Mm-hmm. I just don't think it happens. And it happens because, I will say what one of my bosses, I had 4 district attorneys I worked for. They're all elected in New York. They're not appointed. One of my bosses said to me, Ann, you never met a defendant you didn't like. And that's true. That is true because if you want to say it in a colloquial way, Bad people do good things and good people do bad things. And if you can't look at the world that way, you shouldn't be in a human job. You shouldn't be dealing with humanity. And so every case I looked at as a prosecutor and every case I looked at as a public defender, we did rewrite the sentence. And I've been doing that my entire 43 or 44-year career. I also teach law school so that the students can carry it forward. They need to carry it forward. They need to see glimmers of hope in the criminal justice system when everybody talks about it being broken. And there are a lot of aspects that are broken, but not every single solitary thing is broken in the criminal justice system. And if you tell people things are broken, they never want to fix it. They think they're going to discard it. They think it's not worthy of being fixed. And I think that's a terrible message to send to students, that it can't be fixed, because they're the ones that are going to fix it. We can try to give them the tools and help them along the way. And certainly conferences like this and funding them are really important. But at the end of the day, it's going to be them that fixes this criminal justice system. And the people in this room are talking about the tools to fix the criminal justice system. So I'm happy to have had that experience. I will say that, that this panel is great because legislation matters. And what the tools that the legislature gives us to rewrite a sentence matters. But then it takes Judge Weinstein, it takes people like that to throw it out and say, I'm going to do what I think is important because it's the right thing to do. Luckily for me, as he alluded to, I am elected to the Supreme Court of the state of New York, which gives me license to do a couple of things. First of all, I'm 67 years old. I can only work under the state constitution till I'm 70, and then I could work till 76 if the Office of Court Administration allows me, saying there's a need, and I have the physical and mental capability to do so. So my term is longer than the time I'll ever spend on that court. So I don't need anybody to elect me. I don't need anybody to appoint me, and that gives me a tremendous amount of judicial independence that the federal judges enjoy, but state judges do not. And that allows me to rewrite the sentence. And I'll just give you one example of how I do it today, because I've had these jobs. I've had policy jobs, and I've had investigative jobs, and I've had trial jobs. Right now, I am a trial court judge, and I do two things. I try cases, but also I run the largest drug court in New York State. It wasn't always the largest drug court in New York State. In fact, I doubled the caseload in probably 7 or 8 months that I'm there. And the reason I think it's doubled is because I was a prosecutor and because I was a public defender, and I knew how it felt from both sides. So now we have about 550 cases there. The caseload has changed dramatically from when I started all these programs many years ago. Mostly it was drug offenders, sellers, buyers to support their habit. Now, almost exclusively, I'm elected in Brooklyn, but I sit in Manhattan. It's almost all people charged with theft-related offenses, burglaries, grand larcenies, and felonies, not misdemeanors. And so it's a different population, but the needs are somewhat similar and somewhat the same. What I also have, and this we can talk about the future, is what do I have? I'm funded for 40 mentally ill people who have serious mental illness. Funded for that. I have 135 people who are dually diagnosed. I don't have the resources to do it, but we do it anyway. We just do what you have to do, because when that person's sitting in front of you, and you know what justice looks like, you can't say, I don't have the resources, I don't have the funding, I don't have the this. You have to do the best you can do under the circumstances. So that's what we've been doing, and I'll just finish with this, that the most recent thing we're doing is the district attorney changed in Manhattan. I'm sure people are aware of that. That Cyrus Vance left, and Alvin Bragg is there. Some of you may know him because he's the prosecutor in one of the 4 Trump cases, if you don't know who the Manhattan DA is anyway. He has a tremendously changed policy about all-term sentencing. That's one of the reasons my caseload has gone from like about 220 to 550. And so a lot more cases are there. But because his policy changed, the people who went into that court years ago, may not have gone into the court. They talked about net widening in the beginning of this. And so what we've started to do, say I have a person who, and they talked about individualized justice from the federal panel. We do that too, but at some point, a person may not be committing any more crimes, but he's or she or they are still using drugs. So how do you do a harm reduction model in this current state of affairs? So what we started to do a little bit on a case-by-case basis, somebody's not committing crimes anymore, but they cannot stop using the drugs. We end up, instead of dismissing the cases like we do with the people who stop using the drugs and also stop criminal behavior, we end up allowing them to withdraw their plea. They don't have a felony anymore. Now they may have a misdemeanor. They don't go to jail or prison. They have a conditional discharge, just conditioned that they don't get rearrested. And so we're doing in 2023 what people didn't do in 2020 or 2015. But the moral of the story is that it has to grow. It has to change with the circumstances. And what we incubate in the states does then go to the federal courts. And you heard from the Eastern District. I used to work with the Eastern District in New York a lot about the things we did in the Brooklyn DA, that the Eastern District, whether it was the U.S. Attorney there or the court system there, that took to heart and saw their own version of it. So thank you for inviting me. Thank you for seeing all my wonderful friends. And I'm going to pass it over.
Thank you. Thank you so much, Justice. Who here is a little bit jealous of the judicial independence that you have?
You have to be
Nice.
old to get it.
Now I'm very pleased to introduce Stephen Talpins, who is the Chief Assistant State Attorney down in Miami-Dade County, a fellow Floridian, my new adopted home of Florida. He oversees a variety of divisions within that office, from gangs to guns to felonies to juveniles, giving you a really broad overview of what's going on in Miami-Dade County and beyond. But in addition, he has partnered with several national organizations on developing policy and practices to guide the future of criminal justice across the country, making him actually named one of 20 to look for by the Century Council, which is extraordinary. But please, we'll love to hear your story.
Thank you. In the 1980s through the early 1990s, Janet Reno was the state attorney in Miami-Dade County. 1993, she became the Attorney General of the United States. While Janet was state attorney, a woman by the name of Kathy Fernandez Rundle rose through the ranks of the office. Kathy didn't just have a JD, she had a master's in criminology. So she had a very different view of the criminal justice system than is traditionally seen, especially among prosecutors. In 1989, Janet asked Kathy to develop a program to better address people addicted to drugs. 1989, we were coming out of our cocaine cowboy days in Miami. You may not know, but Miami had a drug problem. We also had a violent crime problem. Those two things tend to go hand in hand. And Kathy came up with the idea of drug court. And that year, she helped implement the nation's first drug court. Think about how courageous this was in 1989. In 2023, it's easy. There's a ton of research behind it. Nobody's afraid to create and implement programs like this. But in 1989, this was extraordinary. It took extraordinary vision and extraordinary courage. And to give you an idea of how much that took, I'm going to tell you my story in a second, because it's a very different story than everybody else's. Riding on the success of drug court, when Kathy became state attorney in 1993, she vastly expanded our diversion offerings. I would venture to say that today nobody offers more diversionary type programs than we do in Miami, and I would be happy to debate that with anyone who wants to debate that. So what happened? In 2003, I got a fellowship with the National Highway Traffic Safety Administration, NHTSA, and I was asked to go around the country and talk about the efficacy of DUI treatment courts. And I'll never forget that call, and neither will my program manager, because it's probably the first time she ever heard the word no from one of her grantees. I said, I'm not doing that. She said, what do you mean you're not doing that? I said, I'm not going to go talk about treatment in the criminal justice system. That's a load of crap. She said, what, are you kidding? Your boss created the first drug court. And I said to her, I don't care who created it. It's nonsense. It doesn't work. She said to me, well, what do you think should happen to them? I thought it was a trick question. The answer was obvious to me. Listen, I grew up in the 1970s on Dirty Harry and Godfather. I knew what the answer was. Jail! And she said to me, well, what do you do when they get out of jail? I said, I send them right back. She said, what do you do then when they get out of jail the second time? I sent them to prison. It was simple to me. Incarceration was the answer to everything. A very traditional law enforcement officer, prosecutor's view of how the criminal justice system should work. And she said to me, well, you go do your due diligence. And if you still feel that way, we'll figure out what to do with you. I don't know about you, but the idea of a federal agent or employee or wherever the heck she was, figuring out what they're going to do to me? What are you kidding? All right, so that meant war. Okay, you got to picture this. Young male prosecutors, 30s, you know it's on, right? I'm going to set out to prove that I am right, everybody else is wrong, right? Typical young male prosecutor of my generation. And I did. I set out to do that. I spent hundreds of hours. I read literally everything written on treatment in the criminal justice system, everything I could find on treatment courts. And after spending all that time, and by the way, I encourage you to do the same thing, we should all take this similar journey, I learned a couple things. Number one, never doubt Kathy Fernandez-Rundle. That was the first lesson. Because number two, she was absolutely 100% right. I was on the wrong side of the issue. And I talk about it, whenever I talk to different groups about this, I joke about doing my penance ever since. But it's not really a joke. I'm absolutely positively serious about it. These programs work. And I'm speaking to my fellow right-wing Republicans in the group. Y'all need to take a look at the data, because when you do, you're going to see that if it's done right, we can not only improve public safety, we can reduce crime, we can help people, and we could save tax dollars all at once. What is a more conservative vision than that? And yet it is the exact same vision shared by those on the completely opposite side. When we talk about this being a bipartisan solution, because it's not just a bipartisan issue, we talk about this as a bipartisan solution because anyone who takes the time to look at the research, to look at the data, is going to realize that if we effectively separate out those we can help from those we have to incarcerate, we can get the absolute best results. Help those we can, rehabilitate those we can, incarcerate those we absolutely must. It's so simple, and yet it works. And I've seen people criticize the jurisdictions that are attempting to do this all over the country. And some of the criticism is valid, because sometimes if we move too fast, if we don't think strategically, if we don't employ smart justice, we get ahead of ourselves and undermine deterrence. But what happens when you do this right? What happens when you do this in a stepwise, strategic fashion with great leadership and buy-in from all stakeholders, including law enforcement? What happens when that happens? We know the answer to that. In Miami-Dade County, both the violent crime and property crime rates have dropped more than 75% since Kathy took over as state attorney in 1993 and vastly expanded our diversion offerings. This works. It is really that simple. So I thank you for your time, and to my friends on both sides of the aisle, it is a bipartisan issue. This works, and I will be happy to share the data with anyone who wants more information. Thank you.
Thank you so much. 75%, that's nothing to sneeze at. And I think your point about creating the first drug court in 1989 cannot possibly be undersold. I mean, 3 years earlier, Congress passed legislation that sentenced crack cocaine 100 times more seriously than powder cocaine. 3 years before that, and she was doing that. I mean, that's incredible. So next, I am incredibly excited to present a dear friend of the Justice Action Network, Representative Tarra Simmons from the great state of Washington. But that title sort of buries the lead just a little bit. She is also the first statewide elected official in the state of Washington who also happens to be a formerly incarcerated person. So just bravo for that, by the way. Thank you for personally breaking down that particular barrier. But it's not enough for her to just have one job. She also runs the Civil Survival Project in Washington that helps other formerly incarcerated people regain some of their legal status and footing that we all enjoy. But Representative.
Thank you. Thank you so much. It is wonderful to be here. I don't know a lot of people in the audience, which means I get to meet new people after this. And it's really an honor to be, only 3 years into my legislative career, I think 5 years into my legal career, and on a panel with giants in the field who can teach me so much. I am proud that in the 3 years that I've served in the legislature, I've been able to pass a lot of bipartisan legislation. I've prime sponsored and got through 11 bills and probably have my fingerprints on 30 different criminal justice bills. And, I definitely come to this work, the reason I ran, I never thought I would be in politics. It wasn't something I grew up thinking I'd do. I never thought I'd be a lawyer. I grew up in a really bad neighborhood in Stockton, California. My father was a crack addict. My mother was an alcoholic. I'm the first person in my entire family to ever even graduate from high school. And that was after becoming a mother at 14 years old and being trafficked and growing up in severe poverty and violence. And so the fact that I'm here today is a miracle in itself. The reason I ran for, or the reason I even became a lawyer, was I was involved in the juvenile justice system beginning at the age of 11 for stealing food because my father would sell our food stamps for crack cocaine, and I was in jail and prison. And when I got out of prison the last time at 35, I had been away from my children for a couple of years, and I didn't have very many opportunities. I was working at Burger King, and they were garnishing my paycheck to pay my court fines and fees. But I was committed to my recovery because everything I ever did was a result of adverse childhood experiences and untreated trauma and substance use disorder to escape the trauma. And so when I was committed to my recovery, going to my recovery groups, and found out that even my sponsor, who had like 15 years in recovery, couldn't rent an apartment because of her felony drug conviction. When I was in prison, I was fortunate to meet these law students, and they said, I was advocating for my family law case and from prison, and they were helping me, and they said, you should go to law school. And I said, no way, I don't even know any lawyers outside of my public defender. Like, lawyers are, wealthy, supreme beings. I didn't see myself being a lawyer, but they encouraged me. And so, it was really out of desperation when I was working in Burger King from work release and realizing they're going to keep garnishing my paycheck, and I'm not going to have enough money to get my kids housing, and I don't ever want to leave them again. And I was, toying with the idea of maybe I'd go back to selling drugs, but I wouldn't use them, so then I could pay for my kids to have shoes. And it was like, no, I would get caught again and I would be away from my kids. And so what am I going to do? And so out of desperation, I reached out to a professor at the law school, and I said, here's my complete record. I have 9 felonies, and I've been in the system my whole life. And, I don't know what else to do, because you can't get Pell Grants after you already have a bachelor's degree, and I did have a bachelor's degree, and so I had to do something beyond that. And so it was really on a whim of faith, and reading a book by a guy named Sean Hopwood, who's a professor over at Georgetown Law School, who's my dear friend. I read his book, and I reached out to him, and I said, you're a second-year law student at University of Washington, which was right near my home. I want to go to law school too. Would you help me? And he did. And he helped me write my personal essay, and I got legal advice, and that's where it started. In 2014, I had been out of prison for a year and a half. I just celebrated 10 years home now. And it is amazing. I celebrate that anniversary too. And this year, it was really special because I got to vacate my entire criminal history, and I'm no longer a felon.
There you go.
That in itself was a miracle, because it took a law change and so much work to get there. But so, it was a journey of, people paving the way for me, and now I am paving the way for others. And I graduated from law school in 2017, and although the Washington State Bar had allowed Sean, who served 12 years in prison for 5 armed bank robberies, they had allowed him to become a lawyer. But when I went before the character and fitness hearing, they said I was too proud of the fact that I had gotten the first Skadden Fellowship ever in the state of Washington. And that I felt too entitled to become a lawyer, and they denied me the right to sit for the bar. But fortunately, Sean decided to appeal that to the Washington State Supreme Court. And if you know Supreme Courts, that's the highest court in Washington State, they usually take about 6 months to issue an opinion. But they were so mad at the Bar Association for denying me, but allowing all of the men before me to become lawyers, that they issued a unanimous opinion in the same day. And I got to become a lawyer. So when that happened, there were several legislators who were in the Temple of Justice that day, along with my formerly incarcerated brothers and sisters, and people from prosecutors and judges who I had gotten to know during my time in law school, where I was sharing my story at judicial conferences and working alongside the prosecutor as we were co-chairing the statewide reentry council and all of these things. And those legislators said, one of them was mine, and she said, I'm 77, I need to retire. I've been doing this job for 30 years. But prior to becoming our state representative, she was a lobbyist for the Washington Defenders Association. And she said, I'm not going to retire unless you run. And I said, oh my gosh, that's nuts. That's wild. Like, there's a reason there's no formerly incarcerated people in office, and that's because our past will be used against us in the media. Politics is really not something I ever thought I'd want to do. But I had already shared my story so openly in order to become a lawyer. And I thought if I didn't do it and I didn't break that concrete ceiling, then whoever would be able to. And so I really ran because I wanted to make sure that we can normalize it. I think that people like me bring a really good perspective to both the legal profession and to the legislature. I've been able to build a lot of relationships across the aisle. And, my freshman bill restored the right to vote for people as soon as they leave prison. And I had a Republican co-sponsor alongside me. And that's a pretty partisan issue. At the end of the day, he was the only one who voted for it from my other party, but at least, he did. And he was, pretty, really far right. And I've had really great success in other issues as far as, reentry and collateral consequences and making sure people have housing when they leave prison, removing those court fines and fees. We just worked with Justice Action Network, and I'm really proud that in Washington State, if you're convicted of a felony, you no longer have any mandatory fines and fees. Unless you have restitution to an individual victim, we're no longer asking poor people to pay the costs of their prosecution, which is huge because all of my fines and fees when they were garnishing my Burger King paycheck were not to an individual victim. It was $7,000 to fund the prosecution and the law enforcement, and it accrued 12% interest the whole time I was in prison and couldn't make payments. And that was taking away from my ability to take care of my kids. And so all of the work I do is really led by my lived experience and by the community that I'm connected to, and really just wanting to make this a more humane and cost-effective system, because I know that adding additional trauma on top of the people who end up there, almost everyone I know has a high ACEs score, adverse childhood experiences, has a lot of trauma. And then we add more trauma, both by the conditions that they're kept in, working for 10 cents an hour, being talked down to, being held in solitary confinement, all of these things away from their kids, away from their family, away from their support, and then kicked out with $40 and a bus ticket and no housing, and then that's creating more crime. And what I will also say is that before I was ever incarcerated, I was a victim of serious crime, and so I also want safe communities. I don't want people to be victimized. And so, in the reentry space, I have been able to find people from both sides who listen to me, and one of the other things I'm really proud of is we never funded any reentry services from the state budget until I got there. And now we fund over $200 million a year to community-based organizations. So I've had a lot of wins in the budget as well. And And so I'll save some more because we'll talk more, but I'm really grateful to be here. I'm grateful for the work I get to do today. I'm grateful for the support of some of my formerly incarcerated sisters and brothers I see in the audience, and looking forward to meeting more of you.
Thank you very much, Representative. She's far too humble to say so, but she not only has achieved incredible legislative success, but she's the leader on these issues in her caucus in Washington State now. So it's just awesome to see all of that. And to my fellow lawyers in the room, the audacity of a bar association leadership to use the word entitled about somebody like this, I mean, not okay. All right, so I'm cognizant of time, so I'm actually going to combine two of our questions that we had. So roll with me, if y'all will, please. So we're here to talk about how states can drive the national conversation. So I'd love to hear from each of you about a policy or a practice or a program in your home jurisdiction that's working really, really well that you'd love to see replicated in other states. But then second, would love to hear what's the biggest failure of your home jurisdiction right now? What's the thing you want to tackle next? And we're going to start down at the end with the commissioner.
So now that I'm in county government, we started a violence interruption program and an alternative responder program, and I would encourage more states to do that. You know, we rely on law enforcement for everything. Mm-hmm. Whenever there's a problem, you just call the police, and oftentimes we should call other people. Now, we're funding those with federal money, thanks to the ARPA money that has come in from the Biden-Harris administration, so we can do some creative things. What was the second one?
What's the biggest failure? What's the next thing you want to tackle?
Biggest failure is, I hope this doesn't catch on around the country. I think I'm going to move to Washington State. Which county?
Kitsap.
Okay. Well, you know, I know in King County it was named after a slaveholder, and they just kept the name, but it's named after Martin Luther King.
Yes.
That's pretty shrewd
Yeah.
in King County. But in Texas, after somebody coined the phrase defund the police, what were they thinking? You know, I'm just glad that I was on some panel with progressives around the country, and initially, although I got criticism, I said, who would say that? I mean, did anybody poll test that?
Right.
But in Texas, they passed this state law to keep from defunding the police. You can never reduce the law enforcement budget. Now, that's what you call a non sequitur. That's nuts. So even when I want to go and give a COLA, cost of living adjustment, as an example, to my law enforcement folks, I can never get the money out. And at least in Texas, it must be the national norm, about 2/3 of the budget already goes into the justice system, whether it's civil or criminal. Most of it is the criminal side. 45% of the budget is boots on the ground. Then you got to do the public defender, the DA, the courts, everything else. Now, that's the dumbest idea anybody could ever come up with. So I hope that does not spread around the country.
I would say that the greatest success that New York State had was that our chief judge, many chief judges ago, was a big fan of problem-solving courts. So we right now have 340 in New York State for the 62 counties, which is great. But I would say further than that, that each county has its own flavor. It's very, very local. And I think the state allows that to happen. For example, I'm elected in Brooklyn, but I sit in Manhattan. And Brooklyn's prosecutor at the time was very, very favorably disposed to problem-solving courts. So we had the largest, and Judge Demick is here. You know, he runs an unbelievable mental health court, domestic violence courts, all of that. Manhattan was less, you know, there were different district attorneys, and they were less sanguine about doing that. And so I will just juxtapose the two counties. So Manhattan, Brooklyn has all of these people in treatment for many years at all levels, you know, pre-charging, at the charging level, post-charging, felonies, misdemeanors, and different specialties. And to its credit, the resources are different. It's not like you're in drug court today and your mental health court tomorrow and you're in DV court, but it's all the same players and all the same resources because they demand different attention. And so in Brooklyn, that was that. So I'm elected in Brooklyn, but they take me over to Manhattan. Wasn't as robust. And so what I loved was that Manhattan did its own version. And what Manhattan did was they had a small drug court. They had an even smaller mental health court. So the administrative judge at the time said, you know what? The DA is changing. How do I adapt to that change in real time? You know, and the research is great, but if it's not done in real time, what does it do for policy, people on the ground? It's great for legislators. It's great for people who want to say, well, you know, there's this many people who graduated, a lack of recidivism, and blah, blah. But what does it tell me if I'm the prosecutor, the defense attorney, the judge, about who does best in treatment or why I should take the risk on this person? So in Manhattan, and to their credit, they created what they called an ATI court, which is just an all-purpose ATI court that used existing resources where you didn't necessarily fit into drug court, even with a co-occurring mental illness. You didn't fit into mental health court, and just created it out of thin air. And I think the moral of the story is that it's all local. And whatever the prosecutor is willing to do, whatever the defense is willing to do, whatever the court's willing to do, leadership comes from all different places. And as long as somebody in the jurisdiction has some sense that this works, you can build a program. And you don't have to build the fanciest program, and you don't have to have the most computers, and you don't even have to have additional resources. You can take existing resources and do the best you can. And I think that that's something that New York State did well, because upstate, you know, is way different than New York City. And the things that upstaters have, you know, risk aversion to, New York City didn't, but they were willing to. I was on the District Attorneys Association board of directors, and they would learn from us. You know, the DAs of small counties at the Canadian border would learn from us, and I think that that's something great about New York. Terrible? You know, I'm low on the totem pole at the Office of Court Administration, so I don't want to say anything terrible about New York or what it doesn't do well. I would say, I wish I had more resources. I will say it that way. So.
Very tactful. I love it. Go ahead.
In Miami, I'm proud to say we have a whole slew of diversion and other programs that serve as national models. Just to name a few of them, we are the only prosecutor's office in the entire state that administers a child support program. Why do we do this? We do it to address adverse childhood experiences. We're trying to minimize those experiences, and we see it as a crime prevention tool when we obtain funding for these children from parents who are supposed to be supporting them to start with. We have all sorts of pre-arrest diversion programs, including a robust civil citation program, which Kathy brought first to Miami and then to the rest of the state of Florida. We, of course, still have our drug court, our Veterans Treatment Court based on the same model, our mental health court and mental health programming, all based on the same model. And we have a second chance program where we help people seal and expunge eligible offenses. We have all these programs, but really what I would consider the greatest success is not the programs themselves. It's the approach to criminal justice that Kathy has pioneered. It's the idea that we can look at things in a very strategic way, and instead of just doing what's always been done, we're always looking for ways to do things better. We follow the data and we follow the science to get into a better place. We're not afraid to try new things, and we in fact do that all the time. If they work, we expand them. If they don't, we try something else. And you gotta be willing to be open-minded. Don't be like me in my 30s. Well, there's some who would say I'm still not too far beyond that, but don't be like me in my 30s, right? You gotta be open-minded, you gotta look at the data, you gotta follow the science, and you have to be willing to give people a chance. So I would say it's our smart justice approach that is really what drives everything in Miami. But it's not just our office. One of the brilliant things that Kathy did many, many years ago when she first started as state attorney is she went out and built up support from all the other stakeholders out there. We are in lockstep and work very closely with everybody from the courts to the public defender's office to, of course, our friends in law enforcement and policing. That is absolutely critical. If you want to get something done, you need to get buy-in from all the stakeholders. It's absolutely critical. Today, we enjoy such a warm relationship with the public defender's office that the public defender teaches at our annual trainings for the prosecutors. We bring him in to talk about collateral consequences, things that he's better suited to talk about than I am. We've also brought in formerly incarcerated people to speak to our prosecutors because we want them to hear that perspective. We want them to understand that every single thing they do has an impact on somebody. And of course, we bring in victims all the time. It's that global smart justice approach that makes Miami so special and makes us so effective. So what are the problems? I'm going to cheat the same way you did. I actually have it written down because that is the number one problem prosecutors, judges, and public defenders are facing all over the country. And I am going to include public defenders. And let me just say this about public defenders, because this may surprise you coming from a conservative prosecutor like myself. I will tell you, I want a robust public defender's office. I am proud that the public defender in Miami, the elected public defender, is as smart, as good, and effective as he is. And not just because he's a friend of mine from law school. He's one of my heroes. I love the guy. I want a good public defender. You want to know why? Because I'm not perfect. And none of our people are perfect. There is nobody who's perfect, right? We're human beings. Because we're human beings, we are by definition imperfect. I want to know that there's somebody on the other side who's going to catch my mistakes. Because I don't want to be responsible for someone sitting in prison who doesn't belong there. So I love having a robust public defender's office. But the judges, the public defenders, and the prosecutors are grossly underfinanced. God bless our brothers and sisters in blue. They deserve every penny they make. But when you fill the streets with police officers and you train them to be as effective as they are, and you don't do the same thing for the court system, cases are falling apart. They're disintegrating for all the wrong reasons. We need better funding for us. We need to be able to better analyze our cases. You don't want some third or fourth year prosecutor handling a rape case. And that's really where we are today all over the country. To give you an idea, we run, as far as I'm concerned, we have the best office in the country. No apologies to anyone, including New York. I love our office. We have the best elected state attorney in the country. Everyone who wants to be a prosecutor should be a Miami prosecutor. We are funded for 349.5 positions. After hiring a class of 40 in August and hiring an additional 3 laterals in July and August, we are under 240 prosecutors. That is simply indefensible. There's no way the prosecutor offices, and I'll say the same thing for the public defender's offices, there's no way we can give the public the service it should get, the service it deserves when we are under-resourced the way we are. We have to be better resourced. You want better results in court, you want to get better sentencing, you want to have better treatment, you want less wrongful convictions, fund the prosecutors and defense attorneys that were qualified and able to do the job the way it's meant to be done.
Okay, so what is working well in Washington is, during my very first legislative session, I want to tell this story real quick. We were on Zoom because of COVID, so we were all working from home, and it was really, really difficult to learn how to be a legislator from my home office on Zoom. And I never expected this to happen, but the Washington State Supreme Court decriminalized drugs overnight because they struck down our statute in a decision called the Blake decision. We were the only state that didn't have a mens rea in our statute, so you were guilty of possession of drugs even if you didn't know that you had drugs on you. And the case included a woman who had bought some jeans from a Goodwill and didn't know that she had a tiny bit of drugs in the pocket and was convicted of drug possession. And so that made its way through the courts, and they struck it down overnight while I'm a legislator and cited to my Yale Law Review article on collateral consequences. And I was shocked. But that meant we needed to do something immediately. And it was past policy cutoff. We didn't expect this to come. And as you can imagine, 148 legislators and everyone has a different idea. And that was really, really difficult. But we had a 2-year bill with a sunset that basically said law enforcement needs to refer an individual twice to something that didn't exist. And if they arrest them on the 3rd time, then they can charge them with a misdemeanor for drug possession. And, in retrospect, that was not a good thing that happened because there was nothing to refer people to, and police couldn't even track that because there wasn't a data system. But what we ended up doing when we came back in 2023, so this last session, it is a gross misdemeanor, but the bill died on sine die and this never happens, I guess, that the speaker will bring a bill to the floor that doesn't have the votes. But I voted against it because the penalty was going to be worse than it was when it was a felony. So we came back for special session in May, and now we have a drug law where it is a gross misdemeanor, but the maximum you can get is 180 days the first 2 times. But it strongly encourages prosecutors to always divert and law enforcement to divert, and we are building the infrastructure. So now we do have, it took a couple of years to get this program up, but we have recovery navigators in every community that are people who have a history of recovery themselves and working with police. And we're hoping to get people out of the court system because the court system is underfunded because we don't have enough resources to help treat root causes in the community, right? And then the police are arresting people and then putting them and we're spending so much on policing and courts. But if we can actually help people in the community beforehand, treat the root causes, I really think that's the solution we all want. And so this is, our drug possession laws are probably some of the most humane in America, and we're really trying to meet the need before arrest and prosecution with people who have been there, who can reach out and actually reach these people and show them a better way. So that's one of the things that's going well. To be determined though, right? Because research is going to dictate how effective it is. One thing that is effective that we've had for a few years now is something called graduated reentry. And so when people are coming out of prison now, they can leave 18 months early, but they go to work release for 6 months where they're in a reentry center, and then they go home on home monitoring for a year, but it's coupled with culture change within our department. Some of us have been going to Norway and really seeing how they do things there, which is about building relationship with the incarcerated individual and then also treating them like a human. It's about centering humanity. So they're caseworkers, and the people who I met that are incarcerated in Norway look at their correctional officers as their mentors, and they have a trusting relationship. And when people leave a Norway prison, they leave with everything they need, and they've been, going out in the community for a long time before they actually leave for good. And this is kind of that model we're trying to incorporate in Washington, both while people are currently incarcerated and during the reentry process. And so they go home for the last 12 months, but they have a correctional officer, and we're changing that culture to where they are more like a case manager. The things that are not going well, number one is we fail victims all the time. And this is really important for someone like me because it is very much intertwined with sentences. Victims consistently are looking to the system to heal something that's the system's never going to heal. But they think they can get that in the excessive punishment of the person who harmed them. And that's not going to fix it. If you give the person that raped you 10 years in prison, 20 years in prison, 30 years in prison, it doesn't matter. That's not going to heal my trauma, right? But we give long sentences and longer sentences throughout history with no parole. Like in Washington State, we have no parole. If you're sentenced to 60 years as an 18-year-old who committed a homicide, you're serving 60 years because we don't have parole. And many states don't have parole or a second look. And we're giving long sentences because we fail victims. If we helped victims heal and give them what they really need, which is mental health and trauma therapy, and maybe if they're in domestic violence situations, an opportunity to become financially secure so they don't need to rely on an abuser to meet their needs, and we give them what they need, then we can actually see sentencing reform. But until then, we're going to keep having this consistent debate between people who feel we need to be tough on crime in order to listen to victims, and people who want to see individuals have a second chance.
We are at time. Yes, we are at time. Please join me in congratulating all of the panel and thanking them for their wisdom.
Third floor Continental Ballroom. See you in a few.